students, welcome to Tarun IS. Today we will be discussing daily current affairs of 7th of November 2022. So let's start with the first news of the day. The first news is about the NIVESHAK DIDI. Now recently, Indian Post Payment Bank had conducted India's first floating financial literacy camp around Dal Lake, Srinagar in the Union Territory of Jammu and Kashmir. I've taken this news from the Indian Express, and the key points are that it was launched by the Indian Post Payment Bank in collaboration with the Investors Education and Protection Fund Authority under the aegis of the Ministry of Corporate Affairs. So we will separately look at the Investors Education and Protection Fund Authority. Basically, the aim of the NIVESHAK DIDI campaign was to promote financial literacy by the women and for the women. Now this concept is prevalent especially in the rural areas because women are more comfortable in sharing their personal life, in sharing their personal opinion with other women. So therefore women will empower another women. So that this is the concept, and that's how the Indian Post Payment Bank is increasing the the financial literacy. Financial literacy is very important from your mains perspective as well. If you consider General Studies Paper 3 topic inclusive development. So when we speak of the inclusive development, we also speak of the financial inclusion. In order to achieve the financial inclusion goal of the Government of India, we need to have financial literacy, and especially amongst the women. So the concept is basically based upon women for women. It was conducted around the Dal Lake, the famous Dal Lake of Srinagar in the Union Territory of Jammu and Kashmir. Now let's look at the Investors Education and Protection Fund Authority. Under the Section 125 of the Companies Act of 2013, in order to administer the Investor Education and Protection Fund, this authority was established. The main objective of the authority included to promote the investors' education, their awareness, and protect their and refund unclaimed shares, the dividends and other amounts transferred to it under Section 124 and 125 of the Companies Act of 2013 to the rightful claimants. The next news of the day is about the disqualification of the convicted legislators. Now we know that India has representative democracy. India has what? India has representative democracy. However, in Indian democracy, there should not be any provision for the corruption and for the criminals. Therefore, the Representation of People's Act provides certain provision for disqualification of the convicted legislators, whether they are the member of the parliament or they are the member of the state legislatures. So therefore, this was a news with respect to when two Uttar Pradesh legislators, they were convicted in the criminal charges. However, only one of them had been disqualified. I have taken this news from the Indian Express, and let's talk about the key points with respect to this news. The Section 8 of the Representation of People's Act 1951, it contains provision which aimed at decriminalizing the politics. If we consider the report by ADR, that is Association of Democratic Reforms, this is an NGO. This NGO says that approximately, more than 40% of the legislators in the parliament, they have criminal charges pending against them. The serious criminal charges. Not for the petty crimes, but for the serious crimes. So if we look at the graph with respect to and if we start tracing the criminalizing tendency from the 15th Lok Sabha to 16th and then to 17th, so we generally see we see an increasing trend when it comes to candidature of the criminals when we speak of the representation in the electoral process, and as well as the candidates who are declared elected, they all have been facing certain or the other criminal charges. So this trend of criminalization of the politics is increasing since the 15th Lok Sabha. And in fact, there were certain people who were elected despite the fact that they did face the criminal charges. However, the trend has been increasing over the period of time, and So in this context, we will talk about the laws which are responsible for the disqualification of the convicts. Now section 8 does provide it aims at the decriminalization of the politics. So there are two categories of the criminal cases that attracts disqualification upon the conviction. The first category entails disqualification for 6 years. Excuse me. And this includes criminal offences such as corrupt electoral practices. Corrupt electoral practices. All right. Now let's talk about the major offences which are included in the RPA Act 1951, and we would see that how this act attracts. I mean, it aims at decriminalizing. The first thing, and we talked about the section 8. Now let us look at the IPC. So major IPC offences which are included when it comes to conviction and also when it comes to the disqualification. So if I speak of disqualification, there are two ways to disqualify a legislature. The first one is the anti-defection law under 10th schedule of the Indian Constitution, that was added to the Indian Constitution during 1980s during the prime ministership of late Mr. Rajiv Gandhi. And the second provision is the 105, the article 105, and I mean this article 102. So it provides for the disqualification. It provides for what? Disqualification. So these are the two ways under which the legislature can be disqualified. However, the offences for which he or she can be disqualified is using the hate speech or the speech that causes, because hate speech has not been defined in our constitution, not even in the law. However, Law Commission did provide for its definition. But any speech that causes enmity between two groups or communities under section 153A of the IPC, and when the hate speech and when the speech that spreads enmity between the communities is done so in the place of worship, that is section 505 of the IPC. Bribery, impersonation, other electoral offences, rape, etc. are all included as the offences that can attract disqualification. There are serious provisions for the special laws such as Protection of Civil Rights, Customs Acts, and the Unlawful Activity Prevention Act, etc. There is a law for the prevention of sati, corruption, terrorism, and insult to the national flag and national anthem. These are certain laws which attracts the disqualification upon conviction. Now, what is the legal protection that is available to the legislature? If we speak of the section 8 of the and clause 4 of the RPA Act, legislatures could avoid immediate disqualification until 2013. Because post 2013, in the Lily Thomas versus Union of India case, the Supreme Court struck down the clause 4 as unconstitutional. Thus it removed the protection which was enjoyed by the lawmakers. So therefore these two points are related to each other. That means the legislature could avoid immediate disqualification until 2013 only, because in 2013, in the famous Lily Thomas versus the Union of India case, the Supreme Court has struck down this provision by declaring it as unconstitutional. That means it ultraviolates the Constitution of India. So the provision said with respect to the MPs and the state legislature, the disqualification will not take effect for 3 months, and if within that period the legislature it filed a appeal, the conviction will not take place until the disposal of this appeal. So this was the provision under the section 8 clause 4 of the RPA Act. However, this provision was struck down in the Lily Thomas versus Union of India case. So this case is very important when it comes to the measure that would reduce the intensity or the trend of this criminalization of the politics. the question arises, can the disqualification be removed? Can it be removed? The Supreme Court has the power to stay not only the sentence but also the conviction of the person. Not only the sentence but as well as the conviction. In some rare cases, the conviction has been stayed to enable the appellant to contest an election. However, the Supreme Court has made it clear that such a stay should be very rare and for some special reasons. The next news of the day is about the First Amendment. The Supreme Court has agreed to examine a challenge to the expansion of restrictions to the fundamental rights to freedom of speech and expression, that is Article 19 of the Indian Constitution, that was made by the First Amendment to the Indian Constitution. Now we have to look into this provision, because this Article 19 was amended by the first amendment of the Constitution, amendment in the Constitution of India, and it had basically expanded the reasonable restriction. It expanded the expression reasonable restrictions. Now we know that the fundamental rights are not absolute in nature. They can be abridged by the Parliament under the expression reasonable restrictions, but within the, this is the present status, but within the basic structure of the Constitution. That means any amendment in the Constitution should not alter via the basic structure of the Constitution. So I have taken this news from the Indian Express. Now let's see what the constitutional position is. Now when we speak of the Article 19, Clause 1 in Part 3 of the Constitution, that guarantees the fundamental right to freedom of speech and expression. Right. Now the Article 19 and Clause 2, it lists certain reasonable restrictions, and two of the most important reasonable restrictions are public order and security of the nation, or sovereign security. Now the amendment made several consequential changes, from exempting the land reforms from scrutiny to providing protection for backward classes in the Constitution. Now if you see the First Amendment 1951, it was done during the Prime Ministership of our former Prime Minister Jawaharlal Nehru. Now let me bring to your attention a very important fact about India, that during the British colonial period there was change in the land revenue system, and Britishers they had introduced many revenue settlement systems, such as permanent settlement system, which was also known as the zamindari system. We had Rayotwari system in the Deccan area of Andhra Pradesh and Maharashtra, etc. We had Mahalwari system in the regions of Punjab and northwestern frontier provinces, etc. So when we look at these revenue systems, they basically had consolidated the land and had empowered certain section of the society to have authority over the land. Now this created disparity and inequality to a greater extent, which was against the Constitution of India, and especially against the Article 14 of the Indian Constitution. Thus, in order to bring the equality and introduce the concept of equity in the independent India after the Britishers had left India, so we had to carry a legacy that was based upon the equity and equality of the citizens of India, discarding any social inequality that existed in India due to the caste system or any other socio-economic system that had prevailed or that had continued or was introduced by the Britishers. Now, one thing needs to be clear here, that in order to do so, there were certain changes which were needed, especially when it comes to the socio-economic expression. Land is a very important component of the Indian economy, because Indian economy is based on the agriculture. We have agrarian economy with more than 40% of the population dependent on land, and when we were newly independent, more than the 50%, or in fact I can say that more than 60% of the population was dependent on agriculture. So agriculture holds a very important role in the Indian economy. and land is not considered only as an economic factor, but rather it was the matter of prestige too. So in order to introduce the land reforms, we had to make an amendment in the constitution, because Article 19 provision F provided for the right to property. So right to property had to be abolished, but it could not be because it was the fundamental right. Later on, did 44th Amendment to the Constitution in the 1978 did abolish the right to property and was included as a legal right. However, it is no longer a fundamental right. So in order to introduce land reforms, the first amendment was done in the Constitution, and 9th schedule was added. Now this 9th schedule said that any provision included in the 9th schedule shall not be liable for the judicial review. All right. So this was the case. However, after the Keshwananda Bharti case of 1973, that is post 13th April 1973, all the constitutional amendments are subjected to judicial review. All right. So yes, it made several consequential changes, from exempting the land reforms from scrutiny to providing protection for the backward classes in the Constitution. So this was about the first amendment of the Indian Constitution. So what was the position before amendment? It said, now this is what has been written in the Constitution. It's a very big definition, but the point is, the essence of the constitutional provision is that nothing in the subclause A of the clause 1 shall affect the operation, because Article 19(2) provides for what? The reasonable restrictions shall affect the operation of any existing law insofar as it relates to or prevents the state making any law relating to libel, slander, to defame, contempt of court, or any other matter which offends against the decency or morality, or which undermines the security or threatens to overthrow the state. That means we are talking about the sovereignty here. We speak of what? We speak of the sovereignty here. Now after the amendment, what is the position now? Nothing in subclause A of clause 1 shall affect the operation of any existing law that prevents state from making any law insofar as such law imposes the reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India. So this is the first expression which is added, right? Public order, the second point, the decency or morality, the third point, in relation to the contempt of court, the fourth point, and defamation or incitement of offense, that is the fifth point. So certain reasonable restrictions have been added. That means the scope of reasonable restrictions was expanded post amendment. The first point was the insertion of the reasonable restriction, that is the expansion, and the second point is the adding the essence with related to the public order and the incitement of offenses. Now here this term is very vague. It has not been defined properly. What would lead to incitement of offenses? How would you define public order? So these are a few vague terms. There are two important Supreme Court cases and the judgment thereafter. The first important case is the Ramesh Thapar case, and this case is related with the freedom of speech. Now what happened? Ramesh Thapar, he was associated with a newspaper. And this newspaper was banned on the provision laid down in the Madras Maintenance of Public Order Act 1949. Now what had happened? The government argued that the writings in the newspaper undermines the security of state, and they could be well within the scope of the reasonable restrictions that are provided in the Article 19 for public safety and public order. However, the Supreme Court struck down this provision as unconstitutional in the Ramesh Thapar case. Ramesh Thapar versus the versus the state of Madras in 1950s, and it upheld the freedom of speech and expression. Now, if we look at this case, then freedom of speech and expression, can there be absolute freedom of speech and expression? Definitely no, there cannot be. In fact, there should not be. However, the right to express oneself should be well within the constitution. It is both for the state as well as the citizens to exercise their right well within the provision of the constitution, or I should say the constitutional morality. Citizens are also not empowered to say anything that they want, because there is an expression that your fundamental right ends from where the fundamental rights of the other person begins, right? So this has to be kept in mind. So any freedom of speech and expression is liable for certain restriction if it incites enmity between two groups, that is hate speech, although it has not been defined. In fact, there is one ruling by the Supreme Court of India in the Baldev Singh case that even the sloganeering would not ultravire the provisions laid down in the Article 19. A person has the right to say, a person has the right to dissent. Right to dissent is also one of the rights in the Article 19, freedom of speech and expression. However, if the said thing, if the thing which is either said, written in the verbal or the non-verbal expression leads to offences, if it leads to incitement or if it leads to collapse of the public order, etc., etc., then it would be considered as as an act of that is against the freedom of speech and expression. However, before that, if it is not leading to any offences, if it is not leading to any act of any criminal act or any violent act, then it cannot be restricted. A person has the right to express themselves. Citizens of India have the right to express themselves. So that was the first case, the Romesh Thapar case, that actually uphold the freedom of press. That press can criticize the government. Press, not only press, but which is the fourth pillar of our democracy, even a citizen can criticize the government, can dissent from the view of the government. There is another case with respect to the First Amendment, that is the Brij Bhushan case. Now this Brij Bhushan, this case was first for the pre-censorship order. Now one thing needs to be known, that in the Article 19, pre-censorship order is not there. Like you can only censor a thing after its publication. Pre-censorship used to be a pre-independent phenomena. If we consider the press laws during the British colonial rule, then pre-censorship rule was there. However, in the independent India, we do not have pre-censorship. So this was the case of the pre-censorship order. This Brij Bhushan, he was the mouthpiece of this RSS, and he had fought his case. Its publisher challenged the Section 7 of the East Punjab Safety Act, and the law was struck down by the court. So these were the two important cases with respect to the First Amendment of the Constitution in the year 1951. The next news of the day is about the Indian black honeybee. Now recently, an endemic species of the honeybee has been discovered from the Western Ghats. So this new species has been named the Apis carinjondian. Now this Apis, this is the order for honeybees. I have taken this news from the Hindu. Let's look at the key points of the news. The findings have been published in the September issue of the Entomon. This is a journal. It is a peer-reviewed journal. Now, what do we mean by peer-reviewed journal? Peer-reviewed means there are some people involved in the research discussions and etc., and they review each other's research. So this is what the peer-reviewed journal means. It was brought out by the Association for Advancement of the Entomology. Entomology is basically the study of insects. So study of insects is entomology. Entomon is related with the insects, and whenever there is a term logy, it means to study. So entomology means the study of insects. It is after a gap of 200 years that a new species, this is significant because after their findings of Apis dorsata, which is an Indian honeybee that was found in the year that was found in the year 1798 by Fabricius the Apis indica. The Apis is basically the genus and indica is the species because it is found in India, that is why the name indica. So we have Apis indica, we have Apis dorsata, and now we have found a new species, that is Apis carinjodian, which is the black honeybee. It is black in color. You can look at the picture. So after a gap of 200 years, the new species has been found. So this species evolved from another species by the name Apis serena. Now the point is, from the UPSC prelims perspective, these scientific names are not very important. However, you should be aware of the happenings in the science field. Now this is acclimatized to the hot and humid environment of the Western Ghat. This is the incorrect picture. Please don't mind here. This is not the picture. It should have been removed. Now let's talk about the distribution of the Apis carinjodian. It ranges from the central Western Ghats and Nilgiris to the southern Western Ghats, covering from the states of Goa, Karnataka, Kerala and Tamil Nadu. The next news of the day is about the Kali SYAHI. Now, keeping the old traditions alive, the makers of the Kali SYAHI, they prepare this ink during the festivals of Deepawali. I have taken this news from the Hindu. Let's talk about the key points with respect to the Kali SYAHI. Basically, it dates back to the reign of Kachwa rulers some 250 years ago. This Kali SYAHI, it was used to write the royal farmans, and businessmen used it to write their ledgers and accounts. The ink is believed to bring prosperity and ward off evil and bring prosperity to its users. It is made using the natural ingredients like kajal, gond, and it is prepared while chanting mantras. The ink is also believed to have the medicinal properties as some of its ingredients which were used in the traditional Ayurvedic system for the treatment and healing of wounds. So that's it for today. Thank you so much for watching Tarun IAS. Have a nice day.